rig, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
Woo! All right, everybody, we are here. So
We made
we're here.
it.
We made it. I had to brief Jody on everything that was going on. So appreciate everyone having patience. So we are here because there is a special kind of pop-up live, so to speak, emergency live, because there are some things that are going on and we want to update you. Ty wanted us to update you. So I got a phone call from him today. I was not able to record it. I was not able to capture it. It was an unexpected phone call from Ty. And he, got in touch with me basically because he wanted me to go live and to communicate to everyone about a couple of things that are going on in his case. One of which is very, very important, as you've probably saw in the thumbnail, which is that Todd O'Quinn is back in jail. In fact, he's being held in the same detention center as Tyrone Tucker. Okay. Now, they're obviously in separate dorms. They're not being held in the same dorm. They can't do that because, at the end of the day, Todd O'Quinn is a victim of Ty Tucker's, at least alleged victim, I guess is what we're saying, of Ty Tucker's. So they can't house them together. But Todd's being held on some pretty serious charges. So let's pull it up here and see what we can do here with this. Give me a moment. I'm going to share the screen. All right, hold on here. I'll show you guys what's going on. Okay, so I think I got it all shared up, and then all right. Hold on a second here. I got to add you to the screen. Hold on. That's the wrong one. All right. So let's add that. And then let's add to the scene here. And then we're going to put ourselves to the side and throw this over here. All right. So I don't know if everyone can see that or not. No, it's not very big. All right. So let me... let's do it this way. There we go. That's better. That's better. All right, that's much better. Okay, so as you guys are going to see here, this is the booking sheet here for the Monroe County Detention Center. And there is Todd O'Quinn, and he has been booked on one count of grand theft of a motor vehicle, a couple of misdemeanors. It looks like failure to attach a registration license plate and operate a motor vehicle without a valid license. So he's facing up to 15 years in prison just on that charge alone. But the issue is that he also, in his previous case, which he took a plea bargain on, is facing potentially up to 26 years on that charge. Rumor has it around the jail, from what Ty's hearing, is Todd O'Quinn is, we'll just say, marketing himself. potentially to avoid going back to prison, knowing that he is in a very precarious situation when it comes to, when it comes to his legal situation. So, I got to be careful what I say here, but um, the implications are that Todd O'Quinn may not be coming to say things in Tyrone Tucker's favor. Let's put it that way. Which is a very, very big.
Is that because of the plea deal he's taken, or
that's because basically right now the prosecuting attorney's office has him by the ball, so
where
to
they
speak,
want him? Yeah,
where they want him exactly,
yeah.
and he's essentially facing a lot of time, and I believe this is his third felony. If anybody knows about the three strikes law, so he's in a very, very, very bad situation. And of course, the state is well aware. Allegedly, there are implications as well that some things are being said. That Todd O'Quinn's saying things. I think he might be implicating.
Rubbing his mouth off and
Right, that he might be being tampered with. What it could be that that the Ty's trying to like tamper with him, and that people around him are trying to influence his testimony. I think he's trying again. He's trying to figure out a way to give the prosecutor something that would allow him to get some help. And that apparently is what's going on down there.
In John Johnson's position.
Yeah. So it's a huge concern of Ty's because obviously we know Todd O'Quinn. Well, he's a pretty strong witness if he goes by that initial statement he told Officer Brady, which was that he saw a white guy take off his mask, young looking dude, puffy hair, and he takes off.
Photo ID'd him.
Yep, and he takes off in a truck. So to me, I think there's quite a bit of cross examination that can be done if Todd tries to come into court and float that story. I don't think it's going to go well for Todd, but potentially. But then again, you're getting a jury in there who doesn't really understand the case like we do. So now you're going to have a witness potentially be presented in a way that could be looked at as corroboration of what. Remember, if Todd tells a similar story
to John Travis Johnson,
then he now is the corroboration that didn't exist in the first trial, and it will be presented that way. So that's a concern. And again, it's up to Ty to really come this time and make sure he presents a case and not just limp in.
Can he put in to suppress just to cover himself, to suppress his testimony?
As far as what do you mean by that?
The state's going to call Todd under this plea deal.
Well, no, because see, Todd is a victim of the case, so he under the it's slipping my mind, but he has every right to testify. There's no way to block him out. So he's a victim. He has a right. In fact, Ty was going to be advocating.
He really is in the wrong position.
Well, yeah, because at one point Ty thought that again he was under the impression the state was going to try to keep him out. So Ty was prepared to try to advocate that Ty be, brought in. Or not Ty, Todd be brought in under the idea that he has a right as a victim to have a voice and to come in and to speak. And, ultimately that's if things go the way Ty, again, it's a small jail. So word is circulating around about what's going on.
He didn't testify in the first trial, did he?
Oh, no. He was in prison. Remember, it was and so we have a question down there. Yeah, but he could be impeached pretty hardcore if he changes. Oh, absolutely. Listen, he's got he's got loads of impeachment. That could be brought in. But the key is, of course, you've got to have the body cam footage and the statements ready to go to properly admit it and impeach him with it. You're not just going to be able to just pop some of this stuff in court. And I guarantee you, the things that the state doesn't want brought in are going to be kept out. So it's one of those situations where, so Laura dad says, didn't even know Ty was in jail. Thought he was out. Yeah. Well, basically, Laura, to update you on the case,
the proverbial has hit the fan.
Well, essentially what occurred was this. After the first trial, the Judge Jones that you saw preside over the first trial, for reasons not known, he never told us the exact reasons, he decided to step out of the case. It's believed that it was due to his actions in relationship to the police statement, the way they handled the knife and the police statement, things of that nature, and how he let that go, that he was essentially told, there's problems here. It's best if you leave. So he left the case. Unfortunately, Ty made a very bad judgment on the new judge that came in. He had an opportunity to get rid of the judge. He had an opportunity to object to the judge. Ty, for some reason, felt really strongly that this judge was in his favor. I know I didn't. There were others that saw it and thought this guy's not in your favor. But as soon as Judge Morgan got on the case and there was no ability to disqualify him from the case, immediately at the first opportunity, he revoked Ty's bond. And the reason why he revoked his bond was actually pretty spurious. Ty was to go to what had he done for years, an alcohol screening. When he arrived at the alcohol screening, he arrived late in the day and he was told there was a computer error. Please return tomorrow. Next day he arrives a little bit late in the day.
What happens with that process is they get their text message and they have to register, and they've got a certain time limit to go while that registration is open. And because he was in line for so long, that registration ran out, so he wasn't able to do it. So that's what happened for the 2 days running.
And then basically the day 3, he shows up and he was able to go through. He passes the test. The problem was on day 2, the judge went ahead and signed a warrant to violate his bond and revoke his bond. And then not only revoked his bond, but took his bond from $60,000 to $3.1 million. And then failed to provide him any. Normally what would happen in that case is you would have an attorney. Your attorney would get contacted and would make arrangements with the bail bondsman to go get you and bring you back. And there would be a hearing, immediately motions filed for a hearing. Of course, Ty's pro se, so he doesn't know what to do. As a result, they don't send the bail bondsman. The bail bondsman does try to get in touch with him, but apparently Ty was confused and thought this was a previous bail bondsman that was trying to contact him. So he decided he was just going to hop a plane, head back down to Key West. He had his.
He thought all of his pretrial stuff was like. Once his bond was revoked, so he was going to surrender himself.
Well, he did, but he was actually. Now on that point, he was told by several people I know firsthand that was not the case, but he believed in his mind that made sense. And he was even going, his previous attorney, Jerry Bellarito, was going to meet him at the airport. And he goes to the airport, and what do? They show up and they pick him up. And this is where the disingenuousness of this whole thing comes in. They pick him up, and they don't even bother to look to see where his ticket was. They pick him up and claim he had a ticket to a place they didn't know. And they transport him across the country. And he's never gotten his hearing. He's never gotten the things he was entitled to. And on top of that, Florida case law is extremely clear on this point that you are to revoke bond only as a last ditch effort in a case, because the purpose of bond is not to punish, it is to require you show up. So had he had, say 3 or 4 or 5, dirty urines and non-compliances, it would have made sense that they might have revoked. But he has a chance to come give an explanation to the court, and the court has a opportunity to then give a remedy, which is what happened because there was an incident right before the first trial where he had failed an alcohol test. And what did Judge Jones do in that case? Judge Jones ordered him back to Key West. They had a hearing on it, and Judge Jones opted not to revoke his bond, cautioned him not to let it happen again, and on they went. Not only did they not do anything like revoke his bond, but Judge Jones trusted him enough that during the trial, he suspended all alcohol testing. And then, curiously enough, a month after, well, I guess maybe a month and a half after the trial ends, he has this issue, and the first thing Judge Morgan does is revoke his bond, which he was warning. Well, if you go back to the hearing right before he did it, he warned Ty Tucker that he was going to revoke his bond, because there was also an issue with when Ty was having a problem, which Ty had filed a motion to the court to let them know he was having issues with his ankle monitor.
Didn't charge up. That's right.
Yeah. And the judge tabled that and said, I can't consider it until we deal with whether or not I can stay on the case. And he did that on purpose, because one of the things he was using as non-compliance in order to get to revoking the bond was that ankle situation where the ankle monitor had essentially ran out, and he fell asleep, and they were counting that as non-compliance. So, point of the matter is, some dirty stuff is going on down in Key West.
Yeah.
And they wanted Ty Tucker back behind bars where they have him. And since he's been back, they first tried to essentially limit his access to the electronic case file where everything is filed. So that's part of the reason why he never was able to file a habeas and never able to file for a motion, because he never could get a copy of the warrant that was served on him, which was required in order for him to file the motions he needed to contest bond. Secondly, they refused to give him pencils or paper under the auspices that he wasn't indigent, because at the time he was still married to his wife, who had money and financial resources, but they were not. They were in the process of getting a divorce, so he was kind of in this like rock and a hard place. And then when he went to court and was trying to do verbal motions, the judge told him, you must write it down. And he said, well, Judge,
he didn't have any access to do so.
And he attempted to tell the judge, I don't even have pencils to write it down. And he said, well, Mr. Tucker, I told you, write it down. Following that hearing, he was given, if you've ever gone to mini golf, he was given 2 of those little mini golf pencils.
Yeah,
which is what he's been writing.
Play with Keno.
Yeah, yes. And that's what he's been writing his motions out with. So it's some pretty bad stuff going on down there. And of course, we're now at a point where we get to the second part of this, segue into the second part here, which is after all of these things that happened and motions have been denied, he's been denied the ability to have access to discovery. That's correct, Laura. His wife and he are not together any longer. They are divorced.
Well, ever since he went back inside, Judge Morgan has shut down all media. So no one can access anything since April.
So what he decided, what Ty did in August, because he was scheduled to go on trial earlier this month. What he ended up doing is he filed a motion finally to disqualify Judge Morgan because Judge Morgan was refusing to allow him to get access to discovery, to get access to tapes, to get access to evidence. And he was telling Ty that Ty had to run through the prosecuting attorney's office, which is unheard of, to get his pleadings, to get his paperwork. So as a result, Ty finally had enough and filed a motion to disqualify Judge Morgan and and he's also working on a change of venue motion. Judge Morgan denied the motion, claiming that it was not timely filed, even though he had 2 days left. And that's been verified if you go back and you look at the time this was filed. As a result, Ty decided and let Judge Morgan know he intended to appeal that ruling to the 3rd DCA, to which Judge Morgan recessed and came back and said, okay, we're going to have to continue the trial, and fine. You have 30 days to get the motion in and to get the case to the 3rd DCA. Yep. On October 15th, we're going to come back and see where your progress is at.
Yep.
This is the real thing that Ty Tucker is extremely worried about right now, because guess what? Ty Tucker has to rely on the good old-fashioned U.S. Postal Service to transport his motions. He doesn't get to file things electronically. Yep. And he sent out about 3.5 weeks ago the paperwork needed to have his case looked at on appeal. He's been told it's not been received. If you go on the website for the 3rd DCA and you look it up and Google it, you can Google it, 3rd DCA of Florida. You look up his case, you're seeing an old case from 2021 that's there, but there's nothing there. So he has sent a second packet out. So what we need from you and what Ty needs from you, and what Ty was asking is listen, contact the 3rd DCA and start making inquiries about Ty Tucker's case down there. When is it up? When is it there?
What does DCA stand for? District?
It's the 3rd District Court of Appeals of Florida. So, or it's the 3rd District Circuit Court of Appeals. So, but it's and I'll put this in the chat actually, because I have
I'm doing it now.
I have a link right here that Ty provided me. Give me a moment.
Have you got his M&I number and everything?
His
ID and case file number and...
Well, I have the case file, but it's not going to be under the case file up here. It's going to be under a new case file when it goes down to the court. So you have to look it up by his name.
Okay.
Unfortunately. All right. So I went ahead and put it in. Hopefully it'll be accessible, I think. I just dropped it into chat. There it is. And www.3dca.floridacourtappeals.org. Okay. So look that up. Go, contact them. One of the ways you can help is give them a call and just simply ask, hey, I'm trying to find out information. Essentially making it aware to the people down there that he has a case coming, that he's filed something.
Someone's watching.
And that people are watching. Because what he believes might be happening and might have happened, because it's far longer than what we would expect for it to take for the mail to get the documents there. What they can do when somebody's filing, because what he has to rely on is when they receive it, they have to scan it in and then file it. So if they look at it and say, oh, I don't know what this is, and pitch it in the trash, it's not been filed. What he's concerned is going to happen is that on the 15th of October, when he shows back up for the docket sounding, that they're going to say, you never filed. So it's trial time. And I think that's what Ty is fearful of, because then what Judge Morgan can do is he can set the case for trial within 30 days if he wants to, and get this thing to trial, which is what they want to do.
You failed to
Correct.
Submit your application.
Yeah. Exactly. And that's why Ty reached out. Now, he has indicated at some point he's going to attempt to set up a phone call again for, a weekly update, or one of his, every couple of week updates. So hopefully he'll have more for us at that time. But this was a very quick phone call that he just had literally on the fly with me. We talked for maybe, I think it may have been not even 10 minutes. And went over these things, and he just asked that, can you please, I'm calling you because, number one, he wants me to monitor it. Number two, try to get people to understand what they can do to help out here.
Because who knows what, he could be submitting this mail to the clerk or wherever he has to go through to get it sent, and they could just bin it.
Correct. Exactly. And that's what he's worried.
There's no electronic record.
That is correct. That is absolutely correct. And that's his big concern.
Mm-hmm.
So what we can, the way we can help with that is just simply it's .gov. Okay. See, Tide gave that to me. I pulled it up earlier today. Let me see here. Becca says it's .gov. So let me go in here and see if I put Becca. Another tab here. I'm going to paste it. Oh, no, that's not. Okay, let me go back into my notes here. I was going to say I used it. He had me type it in earlier today, and it went right through, but maybe but .gov would make more sense, unless it just kind of, no, it takes, it is .gov, but it actually takes you there. At least on mine it did. So it took me straight to the Florida 3rd District Court of Appeals. So
are you able to bring that screen up and show people how to?
Yeah, absolutely. Yep. In fact, I'm going to put this new one in there right now. Give me a moment. I'll put the .gov in there. Paste.
It's easier when you can see it.
Yep, absolutely. So this is, let me make sure I got the right tab up here. We're going to remove that from scene.
Oh. Becca, there isn't a GoFundMe or anything at all for Ty, is there, that's been set up?
Okay, good.
All right. So that's the main screen.
All right, hold on a second. Let me get this up to a full screen. I think that's better. Yeah, there we go. I had it kind of minimized there. All right, so this is what you're going to see right here. And then what you want to do is go to case info. So we're looking up right now. I'll show you guys what you want to do. And you want to go to search. And you want to go to party search. And then you want to go to name. Franklin, Tyrone, Tucker.
Hang on, it's not.
And hit search. And then this is going to pull up everything.
It's still sitting on the case info page on the screen.
Oh, it is?
It hasn't.
Oh, it didn't update. Okay, hold on a second here. Let me.
Oh, hello. That's nasty.
All right, let's add this to the scene. And there we go. All right. So is it still? It's still not. Why is it not updating? That's crazy. Oh, no, because I'm back on that. Oh, you know what? I'll tell you why. Because I have to switch.
I shared the screen, didn't I?
No. What it is, it switched off when it did the search results. It switched to a new tab. So I got to re-add it in. There it is. Okay. So now it basically takes you to a new tab. So you can see that here. So you can see where the office.
Search his name, Tyrone Tucker or Franklin Tucker?
Franklin Tyrone Tucker is what you want to search. You can see there is a Tyrone Tucker. It's not him. That was in the 2nd District Court of Appeals. But you could see that the last case, this was his civil case, was down there, 6/9/2021. There's nothing else with Tyrone Tucker. So if his case shows up, it'll show up here at the top. So you can see that this one is.
The second one down, is that not?
That's not him. That's a different. That case is from 1994, and that is a different Tyrone.
Same name.
Yep. Well, it's
Oh,
the
Tyrone Franklin.
Tyrone, right? Yes. Now this one down here, Blankenship State. This is from 1989. There's Tyrone Franklin, and then there's Franklin Tyrone, and then there's Tyrone Anthony Tucker. But the only Franklin Tyrone Tucker case is this is actually an appeal from his civil case that ended up down in the Florida Court of Appeals, which is where this has to go. He's got to appeal the judge's ruling and get them to look at it. But the case will show up here. So and right
So how
and
do
then
they inquire then? Can they do that via this site with an email to someone or?
well, what we would want to do, we're go back here. Let me switch the tab here. So Jody, be ready to pop up. You're gonna get center screen. Well, there I am. Holy cow.
Wrong one, and I was ready and everything.
All right, let's see here. I don't know why. I guess it decided to switch it up this time. It's like a roulette there where we don't know who's gonna pop. So what we want to do here, let's come down here and see. There's a right here, this number right here.
You don't share the screen.
Oh, is it not sharing yet? Oh, shoot. Oh my God. All right, let me add it to the scene. There we go. All right, so there is.
Okay, cool.
Let me go back in here. So there it is. The number right here is this number here that's highlighted. And you can call them 8 a.m. to 5 p.m. and inquire, hey, I'd like to find out information. Franklin Tyrone Tucker's case is supposed to be with you guys. What's the case number? Because there's going to be a new case number issued.
Okay.
When is this case going to be argued? And the good news is, guys.
So that was just under the contact, was it?
Yes, correct. That's under the contact. It's actually, this is the front page. So when you go in, you just scroll all the way to the bottom, and that contact is right there. Now, the good news is guess what? All oral arguments are videotape. We can watch them. So
Sweet.
if he does get a hearing, we are going to be able to see the hearing and see what's going on, and we will get a glimpse. Maybe it gets attention of the big media bigwig. So thank God that we're going to finally get to see this once the case gets there. But we need to get people, inquiring, so that then hopefully somebody's asking questions and let them know he's supposed. And when they tell you it's not here yet, say, oh well, I know it should be because I know he was sending it in via the inner mails because he's an inmate down in Monroe County.
Can he send it registered post or?
Well, no, he in the jail, he doesn't have access to postage stamps or anything like that. He has to send it. I can't remember what the organization is or what the department is that he has to rely on. But there's a department inmates have to rely on that when he files a motion, he has to send it. They have to make copies for him. They have to take all requests for him. They have to do all this stuff for him. So it's it's not a very convenient,
But surely there should have been a log somewhere for it. There has to be, whether he can access it or not.
Oh, well, there should be a log, yes, that he sent something to them.
There should be a log.
Correct. Well, and here's where they would get him on this, right? There's a log, but there's not a copy of what he's sending. So what the DCA might say is we got this and it wasn't in form. In other words, it wasn't in proper form or it didn't meet our protocol, so we just trashed it. It never got uploaded, never got assigned the case number, and then he just doesn't know. And then again, they wait until so Flash Fan 85. Who is this that you guys are talking about, Becca and Flash Fan? Who are we talking about here?
It's another YouTuber, I think, that Flash is.
Is this somebody that's? Is this somebody that's big?
Squid Pro Quo. I'm not sure.
That's her name? Quid Pro Quo?
Squid Pro Quo, yeah.
Okay. I mean, hey, if that Squid Pro Quo, okay. If that's if that's somebody big, or somebody who can get attention, great. Hopefully she would be able to cover this, because again, the more people at this point, the key to this is getting as many people to ask questions.
Oh.
She used to mod for Megan Fox, as in the actress Megan Fox. Holy cow.
Megan Fox, the YouTuber. She's a
Megan Fox,
investigative journalist.
Gotcha. I was going to say, I was like, holy cow.
She's close with what's the other YouTuber that's in trouble at the moment for the snow? He's also a lawyer. I can't think of his name now. It's on the tip of my tongue. Come on, names, people, names. I've had 2 hours sleep. Nick Rakita. Thank you, Becca. You not heard of Nick Rakita?
No.
Yeah.
I have not. No, I've not. I have not heard of him.
He's a law tuber.
Oh, okay. Oh, okay. I just pulled up Squid Pro Quo. Okay, so I see she's covering the Greg case and everything. All right, cool. Well, look. Cool. Yeah, I mean, like I said, it's something that we need as many people as we can to get attention to the case. So the more people that are willing to cover it, more willing to, put it out there. That's what we need, because
I'd like to get Sean McDonough on board. Have you heard of him?
Sean McDonough. Are you talking about? Was he the individual? Was he the individual that was in the Karen Reed case that did the examinations of the car and everything?
Retired DEA special agent. Yes.
Listen, we need someone like him, or someone
to reach out to him on X,
or someone. Well, see, you got to remember though, he got involved with the Karen Reed case because he was from her hometown.
Yes, yeah, but he's all about justice as well.
Well, no, he is. But what I'm saying is the convenience of him being able to get access to law enforcement. He knew all the people up there.
Yeah.
So what we need really is somebody. So him trying to get involved in the case at a level that he could try to affect something. Maybe he does know some FBI agents or something.
Yeah.
It's going to be more difficult than what he was able to do for Karen Reed, because he was actually able to just go. He had local law enforcement connections.
He knew everything right from the beginning before it even came to trial.
And he was able to get access to files and things for him to review. We need to find someone if he wants to get involved, that's fantastic. But I'm saying someone of his caliber who's down in the Key West area who can get in and review this stuff and, try to cover this, and try to review it and have some connections with the right people, because remember, in Karen Reed's case, the Justice Department is involved. They're investigating. They're doing parallel investigations. And in this case, Ty has sent a request, and allegedly the United States U.S. Attorney's Office down there is investigating, but I don't know that there's really anything going on with it, because, at this point, the request he sent in is a pretty standard request, and then he got a number back, and they said they would look into it, and pretty much anybody that sends in a request like that, that's what you're going to get back. So I don't believe, from talking with Ty, that he's ever had a contact with anyone that said this is your agent that's investigating the case or whatever. I know he said that there's people down there, the feds are down there. I think they're looking around because they're investigating Rick Ramsey because of that whole, I don't know if everybody understands the significance of what that situation was that he's talking about, but they have basically a helicopter that they bought, what's it
called?
It's a helicopter basically that would normally be, it's a life flight helicopter. So basically it's meant to get people, because down in Key West, they have several hospitals down there, but say someone needs to get to a trauma center in Miami, you can make it to Miami in 40 minutes. Now, what Ty had been saying, and what the rumor was from everybody that was down, Trauma Star, that's it, was that everyone it was kind of well-known knowledge that they were also using this to smuggle drugs, because Key West is a huge point for drugs to come in the United States, and that these life flights were smuggling drugs up, and that was allegedly at one point maybe being done on a private plane that he bought, but that this was happening. And they found, the federal government busted them and found drugs on the Trauma Star. So everything that Ty had been saying was happening has been confirmed, and as a result, the feds are now poking around down there, wanting to figure out what's really happening, because the Monroe County Sheriff's Department is essentially head of the federal drug task force in that area, and that is a huge, meaning they have a huge area that they govern, because that is the main point where drugs come in. So it's a really, really big job, and they get a lot of money. They make a lot of money off of it, because when they do a bust, they do drug forfeitures and things like that. And that's something that is significant, that I think, if you want to understand the Diddy case and what they're really doing there, is you go all the way down at the bottom of the indictment and you see that they're wanting to forfeit. They've got which is common in federal cases. They have a forfeiture clause in there where if he gets convicted as part of this RICO, because the entirety of the business enterprise is everything Diddy's ever worked for, every business entity that's in his name, the federal government will get to take Bad Boy Records, his clothing lines, his alcohol lines, and they will confiscate it. And he will have a choice of either handing them a check for the value of those, and then he could keep it, but it would require him to sell it in the end, or they will take possession of all the assets, and they will own everything, and Diddy will be penniless. And that will happen whether Diddy goes to jail for 20 years or 1 year. If he gets convicted of any of those charges, they will forfeit, unless it's part of the plea deal that they waive that. But that's what the government normally is after in these cases, and that's what they're after in this case. One of the things is to bring him to his knees and go after, which is billions of dollars of assets that would be taken into their custody. But that's what the big money is, that's what the big money center is down in Key West, is drug forfeitures. And that is why the individuals that were hanging out at the treehouse were pivotal people in drug cases that were leading to multi-million-dollar drug forfeiture cases. And that's why certain people there who were involved in certain high-value cases were being protected that night, and they did not want to get them involved in a double, a killing and a assault and a robbery. So certain people were left out, out of the equation, so to speak. And that's also why they wanted to cover up, because the money that was stolen, some of the money and the drugs that were stolen there, were there because they were there as part of as controlled buys that were happening by the federal drug task force that were happening at the treehouse. And that's
okay. Yeah.
And that's the big, and again, no one's ever asked the question, how did they, I was stunned. I remember when I watched that initial body cam footage of the first officer on the scene, and it was literally, Paula was still screaming. It was just right after it happened. It was like, how did the police get there so fast? And the reason why is because they were in the parking lot of CVS, because that's what they were posting up. They had an operational base right out of the CVS parking lot. And if you go back and you look at the depositions and you look at Pitcher's deposition, some of that's discussed in there about how did cops get there so fast. In fact, the cop that came on the scene, she cleared the scene herself. It took like 10 minutes for other officers to arrive on the scene, and which is very, very unusual. So, those are the things that, again, that help to understand the why and the hows. And the other big thing that is, again, if you really want to understand this case, is you got to go to Ty's website and
YouTube,
and you've got to listen to Penny Phelps talk about the case in the hot mic interrogation room footage. It's a little bit hard to hear. I've got it enhanced. I'm going to be playing it soon. But I was able to get it enhanced. Ty's going to try to enhance it professionally, even better than probably what I can do with my little
how long
software.
is it?
3.5 hours long. And it is exactly, if you want to understand, if you want, again, like I said, all of this is verified. And that's why I said I put it all up. Most of it's up there. The last piece that I need to get up there is the interrogation room videos. And then I want to play Rory's trial, right? But
I'd like to see that. Yeah,
everything else is up. Okay. And when you go through it and you read it, and you read Pitcher's testimony and you read
I've read.
you read all these different things. Look, it becomes clear that they have no evidence against Ty Tucker. But the one thing that always gets on everybody's crawl is the why. Well, why would they go forward with it? When you listen to the interrogation room tape, it all comes together. You can really get a flavor for Phelps and how she's thinking. And basically what she's thinking is she has a white guy with Detroit, the man she is told is Detroit, at the mobile place spending money. And she says, that's got to be the guy. And then when she takes a look at Ty and she sees him, she says, oh, that feels like it's him. That's him. And then in her mind, it's, like, we need to make the case against Ty because we know in the end he's going to be the guy. Like, he's going to be the one the DNA is going to match. He's going to be the one that's going to have fingerprints at the scene. He's going to be the one that ends up on the videotape. Well, here's the problem.
And then she didn't want to be seen like a dickhead for failing.
Well, there was people that fit that. It was Detroit and John Travis Johnson.
Yeah.
They ended up on the videotape. They ended up with the DNA. Well, Rory ended up with the DNA. But Ty never ended up on a videotape. He never ended up being picked out of the lineup by Todd O'Quinn. He never ended up being identified by Paula. And
no DNA anywhere.
But the people
car, not in the masks, not in the knife, nothing.
Exactly. And then, of course, who ends up getting identified as the person, the white guy, all weekend long, all day long? It's JoJo, otherwise known as Travis Johnson, which, by the way, Travis Johnson is in Texas right now, allegedly, but also he has been violating his probation left and right, and he's not in jail. Yeah, he's not in jail. There's been no orders signed for him. Now, will they do that after the fact? Maybe, because remember,
they want to keep him nice because he's got to come back.
well, they want to keep him nice right now, but he's also got two. At the end of the day, they know that they have a guy who did this, right? Who really did this crime. So once they get done locking Ty up, they can revoke him and put him in for the 30 for the robbery.
Yeah, for sure.
And that's what I think they're going to do. But yeah, they definitely want to keep it hanging real high.
He's the one that had the motive. He admits it himself.
Yep. So it's a scenario where, it's a scenario where, for Travis, there's a no-win situation that he's in right now. And I think he's going to come back. He's got to come back. I've thought about that because at one point I was thinking he wasn't. But if he doesn't come back, then he basically is going to prison because they will.
I want to see
that. Well, that unlocks the plea deal. He's out of the plea deal then. If he doesn't show up for court, so he's got to show up for court. So I can't imagine.
Exactly right, Elizabeth. Yep.
I can't imagine. Yep. Well, that's exactly correct, Elizabeth. And that is what I mean. If you go in, don't take my word for it. Go listen to Mansfield tell you that. Go to the video that has the motion to dismiss hearing and transcript. It's read to you by the Windows 95 guy, and you can take Mansfield's own words on the page, and he will tell you he will tell you straight himself that that is the only thing they have.
Oh, hello. Look, see who's popped in then, eh? Welcome, Mr. Baker. Who's you?
Well, that's correct, except that that's part of what Ty is trying to work on, Broken Baker, is he's trying to get these things in this time. And as he said, this is what one of the words he said to me, which kind of resounded. He said the first time Ty was out, right? There was a lot of distractions going on. Believe that. He said he's now sitting in his dorm and all he has to do right now is this. So he has filed and gotten the first trial. He did not, he hasn't had access to a lot of the things that he's hoping he's going to have access to before this case goes to trial again, which he has just secured and gotten approval for a private investigator who's going to be looking into the case. He's going to be having an expert come in, several experts come in on several different aspects. One of them being an expert, which he already had an expert come in once before, but this time he's got to have money to pay him to show up for court and testify. But he's going to have an expert come in and testify in regards to the credibility of Travis and the use of the way the interrogation,
chain of custody.
the read technique, which is a
Oh, yes, yes.
which is a method that essentially, you know, implants memories, and which is exactly what Phelps was using. And he's going to have an expert come in to testify that the statement that Travis gave is classic read technique and it's not credible. So he's got these things. Now, again, as I've said,
a DNA expert or anything like that?
Well, there really isn't necessarily a need for a DNA expert because the state DNA expert says everything's inconclusive. What Ty needs to be able to do in this instance, and again, really honestly, all of that's nice. The only thing Ty really needs to do is the case is very winnable if he just goes in and he cross examines, and he keeps the idea to the jury being that, listen, the burden is on the state. The presumption of innocence is with me. I'm telling you I'm innocent. And if you understand what that means, it means that you've got to, everything breaks in my way. So the DNA is inconclusive. That breaks in my favor. I don't have any DNA at the scene. That's a reasonable doubt. And not only that, but I can tell you it's more than a reasonable doubt. I'm innocent. There's, and then you go forward down the line. What else is there?
Credibility of the witness.
Well, the biggest issue that's going to come into play, in my opinion, is the Judge Morgan. Again, if Judge Morgan makes it to trial as the judge, is they are going to try to present as evidence the implication that Paula said that Ty told her that Matt's blood was on the knife. And they're going to, again, try to float to the jury. The only way he could have known that was him being the killer. The judge is going to let that come in because judges can say, well, that's a matter for the jury to decide. But the question will be is, again, and this is where Judge Jones was wrong, was he would not allow Ty to address it. And Ty wasn't able to bring up his own police statement in the testimony, and he was blocked from doing that. And he was blocked from talking about it in his closing argument. Now, like I said, what Ty should do, because Ty doesn't have a law degree to worry about, he's just got his life. He needs to be very clear when he talks to the jury to say, I was at the police station and I was told this. Now, the other thing he needs to do is he needs to try to make sure he can get in, figure out how to, again, get that piece of the interrogation before the jury, because it shows it's allowed to come in under those circumstances, because essentially the state is saying there's no reason for it, and he gets to now put it in because the state has contested something. Well, he gets to put it in because the state, normally it wouldn't be able to come in just to bolster Ty's statement, but because it's going to somewhat impeach the testimony of Paula Belmont, in the sense that it explains why he would have known this information. So that can come in for a very limited purpose for the jury's consideration.
That's all it needs to be admitted for.
And he needs to be clear that you know, that he needs to get that in. But again, when it comes down to it, okay, what he needs to do, if he would have closed out really strong in that last case, he would have won that case, I believe, because he's got to make it very clear to the jury that there is no other evidence. Like, you go down the list, there's no other evidence that links me there. There's no eyewitness. There's no videotape. Where are the videotapes? In fact, he's got to really be clear on some of these issues, because when he goes to close, he's got to say, there's no videotapes. There's no DNA. There's nobody. There's nothing, right? There's one person. There's John Travis Johnson. And the thing that he's got to go into, he's got to approach John Travis Johnson from 3 prongs. Number one, tell the jury. The judge is very clear. When you're considering the testimony and credibility of a witness, you get to consider their intent, their motivations. Did John Travis Johnson have a motive? Does he have a motive? Is there a motivation for John Travis Johnson to lie? Yes, there is. The plea agreement. Does, you know, so once you establish that, then you say, okay, do you trust John Travis Johnson? Does his story make sense? Is there corroboration? If he can get the expert in to come in and testify about read technique, he can come in and say, listen, the only way John Travis, hey, I saw you dip out there. The only way you can, you know, the only way John Travis Johnson, you know, the story that John Travis Johnson is telling has come from Phelps. And how do we know this? Because it's all wrong. And we know that there were no new facts brought in. It was all coming from Phelps. And if he can get the expert to come in and testify to that, then you say, okay, now you look at the credibility of the testimony, which they're allowed to look at. And then you ask the jury to say, listen, for you to convict me, since the only evidence in this case is John Travis Johnson, when you get back to that jury room, you have to ask yourself this question. If you have a family member who has a life-threatening situation, whatever it is, and the only person in the world right now that you can rely on to make a decision about that situation is John Travis Johnson,
would you do it?
Would you do it, and would you hesitate? If you would hesitate, it's not even whether or not
1 second.
For 1 second, then you got to find me not guilty. But here's the nice part about it, ladies and gentlemen. Do that with confidence, because I am not guilty. I'm standing before you. I am not guilty. And as I told Ty in the last live, he's got to testify through his questions. He gets to testify the entire trial. He gets to tell the jury stuff. He gets to say all these things. You know, and, you know, he gets to tell his story over and over and over again. And he gets to bond with that jury, and he gets to look them in the eye. And he can't be saying stupid bullshit like, you know, well, if you want to believe
correct
me,
if I'm wrong.
you know,
No.
correct me if I'm wrong.
Yes.
You know, if you want to believe me, you know, if you don't, that's fine. No, it's not fine.
No, it's not. I am innocent, and this is what. Yeah. Oh, look, my background's all changed and everything.
So it's just, you know, you've got to just, you know, that's the approach he's got to take. So I mean, it's a very winnable case. It's a very, very winnable case. It's just a matter of him staying on point. And in fact, some of these things he wants to get into could become a distraction to take away from that, because again, many people confuse what trials are about. And unfortunately, I hate to tell everybody, the trial is not about him. It's not about the victims. The trials are about the state or the federal government, and whether or not they possess evidence beyond a reasonable doubt that the law they allege was broken. That is the only question that's before the jury. Now, obviously, the victims are part of that. Obviously, the defendant is part of that. But it is not a search for truth. It is not a search to find the truth. The truth has already been found by the police. That happened during the police investigation. So the state has said we found the truth. And then the state is supposed to present the evidence that they have that proves beyond a reasonable doubt that these crimes have been committed. The defense Now, they have to do that against the backdrop of every piece of evidence has to be examined with the presumption of innocence in mind. Meaning, if there's a conflict of evidence, if there's a question about that evidence, if there's something that the jury can't figure out, all of it, the tie gets broken. It's not just, oh, well, whatever. No, it breaks in the favor of the defendant. And that's because in the process of investigating a case and in the process of coming to the point of charging someone, the state has all these monetary benefits. They've got the benefit of unlimited resources.
Yep.
So the balancing factor in that is the presumption of innocence, which is why one of the things that is close to my heart and trying to point out, and people get confused and think, well, I support these people. I don't necessarily support the individuals, but what I don't support is the state or the federal government trying to subvert the presumption of innocence and trying to take that away from the defendant. One of the ways they do it is they do what they did to Diddy. I know he's not a likable guy, but when they released the Cassie video, that's what that was about. When they perp walk somebody, that's about taking away the presumption of innocence. When they release an indictment filled with all this information and they flood the press and they use the press to talk about denying bond and keep them, all of that is to flout the presumption of innocence and take it away and make everyone presume he's guilty and have everybody forget that he's presumed innocent. He's presumed innocent until the moment the jury says guilty. And then even after that, he's now been found guilty, but he still gets the right to appeal. He still gets the right, and he's technically carrying around
I think that that the presumption of innocence, yes, it's a dying.
Well, it's a dying thing because the problem that we have is it's a dying thing because of the reasons I just said, because the media has killed it.
Mhm.
Because the media jumps in and the prosecutors are again, there is a especially in huge media cases, there is a tremendous battle and war with the presumption of innocence. That's what it's all about. That's what's about taking that away from the defendant. Now, and the other issue is you have defense attorneys that are afraid to talk about it. And you also have in the Carly Gray case, look today. I was proud of the judge because the state was wanting them to, basically the state, if you ever noticed, the state gets into always a lot of these cases you hear them give this convoluted explanation of what reasonable doubt is. And they try to explain away reasonable. It's not all doubt. It's not this, it's doubt. No, listen, it's reason. It's all doubt, reasonable doubt. There's a reasonable doubt. If there's a doubt in a reasonable person's mind about your case, it's not guilty. But they try to play with that. Now, that judge today, who's a pretty damn fair judge and is a damn good judge in the fact that he
see him have his hissy fit?
Oh, I saw him have a sissy fit, but you know what? But I think that's also what happens when you see a defendant invoke their right to a speedy trial. The trial is not a well curated situation where everything's worked out, but they have to have this. They have to have the trial. They have to have.
But the Brady motion too, like.
Yep. Oh,
and she had it there.
Yep. Well, it's like I said, that again, this is a symptom of the fact. Remember, this is a case, believe it or not, this case happened
in March this year.
In March, right. Like this is a case like this to go to trial in the time it did. Like that's why part of their issues is they haven't even had an adequate time to really had the experts look at her for any length of time to really make again, that's in a benefit to the defense.
They did have experts, but the defense didn't respond to any of the motions, so they didn't allow it in.
Well, the judge allowed some of it in, though, didn't he? Because he allowed some of it, even though he said it was. Even though he said it was, he said the prosecution could do a cross appeal, which means basically even if she's found guilty or she's found not guilty, they get, like, let's say she's found not guilty by reason of insanity, that can never be reversed. So they will be able to still appeal the issue for the purposes of setting precedent for future cases. And he said, listen, he's basically said in this case, there isn't case law that I can rely on that says that this shouldn't come in.
Yes. Yeah.
But what I'm relying on is the presumption of innocence, that the defendant, when there's a situation like this, and again, it's exactly what I was just saying. This is a good judge because he said, when I'm stuck in a situation where I don't know what to go, I have to break for the defendant. And
he didn't want to though, did he?
he didn't want to, but
No.
what he said is I have to do that. Now, if it results in a not guilty verdict, there it is. But he invites the state to appeal it so that there is case law in the future to guide judges when they encounter that. I think Flash Fan, what you're seeing again is probably, yes, I don't know where these attorneys came from. I'm assuming they were appointed.
No, apparently one the stepfather is financing it. One is a personal injury lawyer, and the other one is a.
Oh well, there you go.
Yeah, they're not even. They've never tried a
criminal case.
Not an unaliving case. No, one's personal injury, the other one's something else.
Really? Oh wow, I didn't know that background on the attorneys. Well, I mean, the thing is that they seem to be, like, as far as proficient around questioning and stuff like that. I mean, they know their way around a courtroom, but they seem to be. I thought it was just simply they rushed this case to trial, and they were just, again, look, 6 months to get this case to trial is crazy. Oh, one's a DUI attorney, DUI and DUI, and this is totally different. Yeah, so it's a completely different ballgame. But
yes, it should. I was surprised.
Well,
do it at the end. But.
Well, no, it probably will in the end. It's just one of those things where, part of the sanctions is losing the witnesses, and then there's going to be then they can actually take those to the bar later on.
She should file for ineffective counsel for sure.
Well, that could happen down the road as part of an appeal process, absolutely. But the thing is I think that I know it's not going to be very popular, but I think that a lot of people have to understand in this case, again, the presumption of innocence still attaches. Okay. And the problem that you're going to have right now is, if you look at this case, okay, the state came in today with a expert who had less than 1 year of experience. This was his first case. He did not talk. He did not talk to the stepdad, who's a very important witness. And I thought the cross-examination was blistering of him. And he got absolutely he came across as a guy, in my opinion, he was one of those doctors that never thinks he's wrong and always has an answer. Now, it depends on what type of jury we have.
But they had the three before him that basically said the same thing.
Right. Well, it depends. Again, what the state's relying on, I think, in this case is, it's the idea that in a case like Carly Gregg, it's such a distasteful case that what they're banking on is that they have a jury who's looking for a reason to convict. Otherwise, there is, again, remember, in a case like this, they don't have to prove she was insane. They have to prove, the state has to prove beyond a reasonable doubt that she wasn't. So if any juror in that room has a doubt, and when you have a 25-year clinician who specializes in this, and you might say, well, he was hired, so were the states. So the hiring, it's a wash. But if you look back and you say, okay, if that guy raised any doubt in their minds, then, no, but the presumption of innocence doesn't go out of the window, in the sense that the presumption of innocence goes out. It's still present when deciding factors that are present. In other words, if there's a situation that the jury cannot figure out or cannot agree upon, it breaks in the favor of the defendant. So that is always present in insanity cases and in not in insanity cases. Now, the requirement for the state to prove beyond a reasonable doubt that she is not insane is still present. The defense has to, they do have a burden that comes in, but she still could sit there and again, the state has to. That's why the state went in and put 4 witnesses or 4 experts on. That's why, remember, the judge thought the case was going to the jury today. That's why he was so mad. because the state comes in.
So did we.
And well, she does still. Oh, absolutely, Birkenbaker. Yeah, for certain. She doesn't go home. Again,
No.
This is a scenario where, remember, she's got a barrier. And again, that's what they were talking about. I don't know if anybody stayed around and watched the jury instructions, but he said we're commonly going to get this question about, well, if we find her not guilty by reason of insanity, when does she get parole? When does she get released? And he said the answer to them is going to have to be as soon as possible. But but she said probably 10 years will be the earliest she would be considered. And that's because she's 14, so they're consider her. But I think this is a type of a case that look at Sirhan. He's still in jail, I believe. I don't believe he's ever been released, and he was found not guilty by reason of insanity. So just because you're found not guilty by reason of insanity does not mean you're walking out of the doors. It just means that you're going to be in a mental health institution. Well, and that's why Birkenbaker, I think the judge was mad because the state went overboard in trying to prove and they do have the burden, so I understand why they did it, but the judge got mad because it was like they're putting on these people, and then when they put that final witness on, that guy to me he didn't even talk to the stepdad, and the defense attorney basically said there's nothing that would ever move your opinion, correct? That I could present you. And he said, yeah, I already said, and he kind of was trying to say it like, I told the state if I were to, I'm going to present my opinion. But he basically said, once I established my opinion, I'm going to do everything I can to back it up, which is a bit problematic.
I suppose, if that is your area of expertise, you've got to stand firm on it. You can't be half-assed about an expert opinion.
Well, except for that when you look at what he was using, in the fact that he didn't have complete information, I think very much an individual that witnessed her behavior and witnessed her at the scene and could give a contrast to the normal person, or at least his perception of normal, and that is somebody that he should
see the arrest video and all that.
Oh no! I saw it. No, I'm talking about the doctor not saying Heath. He admitted that he did not interview Heath and he was not present in the courtroom for Heath's testimony. And the defense attorney was pointing out the fact that is a very important piece of information when you're considering, because what this guy was saying is he wasn't going to consider the arrest video. He wasn't considering what she said at the police station. He was only because all of that was post, and all of that was after she could see that there would have been a benefit to her to act a certain way. So he was saying the only thing the defense attorney was very methodical in what he boxed him in on. And he said, so he goes and says, I will only consider what's at the scene. So then he says, okay, so if you're only concerned with what was happening at the scene, in other words, what you see on the video, but you're interested in the perception of what was going on at the scene that day, like at that moment, then the best person for you to talk to would be Heath. And that's when the guy said, well, he wouldn't speak to me. He gave me a 6-minute call, and pretty much it was like he was pissed at the stepdad because the stepdad wouldn't have anything to do with him. And it was like, so as a result, you know what? F him. I'm going to go forward. But the point was, this was a point where the guy should have said, well, yeah, that could have been helpful. And I acknowledge that, but this guy boxed himself in and was just pretty much like, and that's when the defense attorney said, okay, so essentially what you're telling me is there's nothing I could present to you right now that would change. He said, and then he tried to come back with, well, and he said, except for the fact, sir, you would acknowledge that an individual who was right there at the scene, got shot by her, saw her face, saw her facial expressions, was present right there in the moment. And also, not only does he have the distinction of seeing her, this is not like some random person at the supermarket. This is somebody who also knew her prior to this incident. And his perceptions and his
he had a baseline to work from.
His interactions has caused him to hire her attorneys. I mean, he believes in her, to be potentially, from his perspective, he's just.
But didn't this witness have access to all those text messages that she'd written just prior to the incident that they weren't allowed to bring in because the judge ruled against it? And then he said it would impeach actual defendant, and so he couldn't really reference them.
Well, he did, but he also said in his testimony, okay,
Elizabeth.
He said in his testimony, and this is why this was effective and this was significant. He said in the testimony, remember, I'm not worried about what was going on before, because there was also things that were being said where she said she heard voices and she saw this. He wasn't worried about what was going on after. He said he was only worried about what was happening at the moment at the scene, because
isn't that the whole point?
Well,
you've got to, at the time of the incident, that's what you've got to assess, really.
Well, right. But what the defense attorney is saying is the greatest evidence at the time of the incident from a person who is evaluating her and can bring perspective would be Heath. And this guy didn't get a chance to talk to her or talk to Heath or really get too much in. And he was saying what Heath said in his perspectives. This doctor, the doctor was saying, I'm not really concerned with that because I believe, that doesn't make a difference to me, because he was saying Heath is in shock. So what Heath is seeing is coming from a point of shock. And the defense attorney was saying, except that you've never heard that. Like, he was actually saying the defense attorney was bringing this information to him, but he was basically pointing out to the jury that all of your assessments and all of your testimony, you've never heard his story at all. You've never heard the things that he said. And the point was, the doctor with 25 years of experience who specializes in pediatric psychiatry did get that information, and he came up with a different diagnosis. So when you're sitting here saying, hey, who's the more credible diagnosis? Is it you on your first case ever? Or is it this guy with 25 years of experience who's talked to everybody, who's actually talked to the dad, who's actually been able to, again, that was another factor where he didn't talk to her dad. And again, this expert was attempting, in his testimony, he was attempting to put the distance between the manic or the bipolar disorder and say that was a hereditary situation. So he was attempting to say the dad did not really have that what he really had was drug addiction. And therefore the bipolar diagnosis was affected by his drugs. So he was saying, I want to put space in between that, because if the dad doesn't have it, then you take out one of the components that says she had it, which would have been a contributing factor to get to where the doctor from yesterday got to say, this is what, this is what, where you get to the legal definition of insanity. So
that doctor yesterday just threw everything that he could think of and so did she. Everything was based on her, on what she reported. It was self-reported, and he just threw everything against the wall and waited to see what stuck. Like, there was, like, I even made a comment before I'd even heard what he'd said, and said, let's throw an eating disorder in there amongst it. And the next thing he said, she was having, she was bulimic or something. And there was every mental health issue that you could note, he listed.
Well, now the funny part is that you brought up the eating disorder. Is that was the one thing of agreement from the doctor today. You brought that up because he had disagreed with everything that doctor said, but the eating disorder.
Yep.
So it's funny you should bring that up as the plus one, and that ended up being the one thing that this doctor said. I disagree with that guy on everything he said, except for we agree on the eating disorder.
Yep.
I think what we could say here, though, is, remember, it comes down to the point of, it comes down to the idea when the jury gets back to that room is saying, do they believe the state proved beyond a reasonable doubt that she couldn't have been insane that day? And I think you have to take the whole package into in a case like this. To me, the big thing is you have a girl with the background that she had, and I guess she had some mental health things leading into this. And I think when you get a jury back there, it's what they feel comfortable with to think to themselves, do we think that she just I mean, again, none of it makes any sense. I mean, it really doesn't.
No.
I mean, when you watch the tape and you see what she's doing, it's such an extreme reaction for her getting caught.
That videotape,
it,
it's cold blooded. It's
yeah. Well, it's nuts. I mean, it's like, why did she do that? Like, why did she do it? I mean, and supposedly she loved her mom, and they had her mom cared about her. It's like, why would you put 3 in your mom? Like, what were you thinking at that
not just
moment?
one, and no hesitation, just and
Oh
straight
yeah,
to the
well,
phone, like
I
within
mean,
10 seconds.
when you hear it, it's just pop, 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 and it's like,
Yep,
are you kidding me? So I
yep.
mean, but the point is that again, that
But if
in and
she
of
was in a
itself.
dissociative state, she wouldn't have been concealing. That shows
Well, that's
indications
not.
of guilt.
Well, see, that's not necessarily true though. And because when you're in a disassociative state, you're not out of your mind. You're not mentally processing things um, on because
Yeah.
there was actually an implication. One of the reasons why I'm familiar with this is because as a young kid, I remember reading. I don't know if anybody remembers the book American Tragedy that was written by Lawrence Schiller about the OJ case. But there was a famed doctor that went in and interviewed OJ Simpson, and he said OJ was so adamant about him being not guilty. He said the only way OJ could have done this would have been in a disassociative state. In other words, and then there was a bunch of stuff explained in the book about what that means. And it says, yeah, you can go in, and I mean, this person is capable of looking like they're intentionally doing all of this. The thing is, their mind shuts down. So somewhere in their head, what they did is there, right? They go under hypnosis or whatever, it can bring it back out. But at the moment that they're doing it, they go in this spot where, again, it's a difficult legal argument to decide whether or not that takes away the criminality of it, and then it also depends on why the dissociative state kicked in. Sometimes it's because you get so angry that like in the case of O.J. Simpson, the implication was he got so angry about something he saw, he just flips out, and his processing of this horrible thing he did caused the dissociative state and caused him to put the memories away. In her
Yeah, but he
case,
didn't pick up a phone and try
well,
and set up someone else
in
right
her,
away.
then that's where the question is hers out of some sort of mental disorder, and that's where the experts have to come in and figure out how that all goes along. But if she was still in this dissociative state at the moment, because she was still, the question is, it's just so crazy and bizarre because it's like she puts 3 in the mom and then she decides, I mean, there had to have been some sort of intent that she was going to try to set this up to look like it was a robbery or a home invasion, and then nobody would think she did it, and she was going to somehow get rid of the gun, and she puts the videotape in the refrigerator, and she's in this kind of frenzied state where she's just like doing all this stuff. But the question
She
is
didn't look
like,
frenzied at all.
but what is she doing? Well, when I say frenzied, I mean she's just like
Yep.
it's pretty clear that's a bad idea if you're going to hide a tape in a refrigerator, where it's just like, oh my God, I did this, where it's almost as if she had a realization she did it
Yeah.
because of that. So then
Not just conscious of guilt.
the question is, do you believe then that she's in, again, I think she's also charged with assault, is she not, or something with Heath? Is she,
I
or
think
is that?
so. With
I'm assuming they're trying all that together.
attempted, I think, and then tampering with evidence.
We'll
But
see.
if you look at the police video, she was calm, rational. She knew where she was. She knew what she was
Well, what
obeying
I'm
commands
interested.
correctly.
Well, what I'm interested to see. Okay, here's what I'm interested to see happen: is if somebody back there in the jury room says, "We believe she was not legally sane when she shot her mom, but then when she realizes what she did to cover up her mom's death, she goes to shoot the stepdad." And if they do a split verdict, not guilty by reason of insanity of the mom, but guilty of the actions against the dad, because it is there that you can see definitively that she actually went forward. It's the mom that says, okay, whatever took over her. But then you start to see the realization to where she starts to formulate a plan in reaction
The
to
formulation must have taken all of 10 seconds because that's what it took for her to text him.
Well, no, that's what I mean. Like,
Yeah.
well, the question is, again, as they said, like, for instance, one of the implications when in the O.J. Simpson situation I was talking about was they said that he could have come out of it when he was, standing there at the crime scene, and that's why it caused him to lose his glove and his hat, and he runs out of the crime scene and runs home. Although obviously there's issues with the amount of blood and where everything went with that, but that was the implication, was that, I mean, they can snap out of it, and then all of a sudden it's like, oh my God, but she was relatively calm. It's just very bizarre. The whole thing is very, very bizarre, but we'll see. But I think what's going to be weighing heavily in this case, which is a big, big factor, I think that is going to be present, is that her age. So I think there could be people in that jury room that could say, I have a hard time believing a 14-year-old is just going to do this if she doesn't have some problem with her, some sort of mental problem. She's definitely.
Look, I agree. She has mental health issues, but I don't think it's anywhere near what.
But the question is when they get back to that jury room with a 25-year clinician who comes in and says, I'm putting my reputation on the line for this individual. Because remember, he didn't have to do that. It's not like he's getting paid some substantial sum of money. She's not rich. He came in and reviewed the case, and this is what his conclusions came to.
That's what they need to reinforce in closings.
Well, and that's what they're going to. And that's why I'm saying when they get there, coupled with her age, and then they say, can I say beyond a reasonable doubt that this young lady wasn't insane? I don't think I can. That's why the judge acknowledged. He said, I understand what I'm allowing this guy to testify to. Probably shouldn't come in and may very well result in a not guilty verdict because it's that strong. And that's why you saw the state pile on for not one, not two, not three, but four, because they're freaking out because they know the strength of that guy's test. I know the presentation and how it appeared, but the resume of that individual, what his background is, and for him to come in and say, I reviewed her and talked to her, that's going to resonate with could resonate with the jurors. But then again, the heinousness of this crime, the way you've interpreted that video, if you get the type of jury, again, who knows what type of jurors are back there, especially if you listen, my dad used to always say this case was won in jury selection, just like Ty's case. From my understanding of how jury selection went in Ty's case, his case, the people that ended up on that jury were not going to be favorable to his situation. So he's got to do.
It's capital, isn't it?
For no,
or has he got 6 jurors this time?
No, he gets 12 because I think it's still considered a capital case in the sense that he faces the rest of his life in prison, and it's the nature of the crime. But he had 12 jurors on the case, and he'll have 12 this coming time. Now, but from my understanding, Ty had a lot of ex-police officers on the case, and people that had law enforcement ties. Yes. And he let that, I guess in Ty's mind, he felt like that somehow was going to be good because I think maybe he thought his arguments would persuade them when he talked about all the corruption. But these are people that are tied to the, Key West, the Bubba movement down there, and that is not great. No, Ty did not have an attorney during jury selection. He was Flash Fan 85. He has not been allowed since he gave up his attorneys. He has not had an attorney in the courtroom ever.
I thought he had someone sitting behind him that he could ask.
Well, he had and when I say in the courtroom ever, I mean he does not have anyone that sat at the defense table with him. Yes, he did have an advisor that was sitting that he could go consult with in a conference room. That was sitting behind him, from my understanding. But sometimes I was even told by people that were in that courtroom that advisor was not always present, that he would sometimes have things he needed to do. So he was available via text sometimes or phone that he could text him during court. So, but Ty has not had the benefit of a counsel doing any aspect of his case since he threw them out of the case in August of 2023. Just unfortunately, just the nature of it, So, and that was again, the judge and the people presiding over the case didn't want Ty going pro se, so they wanted him to have public defender's office. And listen, one thing that I think will, I think one thing that will stand out tremendously when you hear the Rory Wilson trial and you hear the type of representation he was afforded, you will very clearly understand why Ty Tucker feels like he's the better person. It was absolutely atrocious, terrible.
Yep.
The cross-examination of John Travis Johnson, unbelievable. When you consider the things that they had to cross-examine him on, and considering that this is the star witness against Rory Wilson, the jury's got to believe him in that case, in that instance. And
yeah, but they didn't want it. They don't want it to go to trial. They just want to play, get out.
Well, correct. Except what I mean is, but in Rory's case, I'm saying they went to trial. He had a public defender, and she did a terrible job of cross-examining him. She did not come prepared. But what I was told by Ty is apparently there's a cap on public defenders' pay. So basically, his defense attorney was paid. In that case, it was stretched on for 6 years for Rory. So she maxed her cap out. So once she hit that, it was $15,000, and that might sound like a lot of money. It is the first year. Not for 6 years, exactly. And then she had to travel there. She had to stay overnight. She had to do, so for her, she started working on that case probably in the car on the way down to trial, and it appeared that that's exactly the level of effort she put in. It was really poor. But that tells you, again, I've been one to say, get an attorney. Well, let me tell you, if that's what he's got to work with, he's better off on his own, unless he can unless he can attract someone like what Sarah Boone was able to do. But he's got to get creative, but he's also got to have court TV there covering it, or Law and Crime covering it, because the way Sarah Boone, I'm sure if Law and Crime was in the courtroom right now and court TV was in the courtroom covering his pretrial hearings, he would have had somebody who would have stepped up and said, because why? It's free media attention. I mean, that guy that is representing Sarah Boone is doing it completely free because he knows if he wins that case,
exactly,
dude, he just wrote checks for the next 10 years that will be bigger than anything he would have ever gotten from Sarah Boone. So that's that
calls that should never have gotten there. But that was one issue that AJ and I were talking about a while ago about how these trials get through on such little evidence. And my question was, why doesn't, we know that in the trial they've got the burden of, beyond reasonable doubt. But the grand jury has only got a very, very low standard to prove, and it's only the prosecution. Why can't they raise that bar a little bit, and then that would maybe filter out some of the stuff that really doesn't need to go to trial because there is not enough evidence. Does that make sense?
Oh, absolutely. Well, like my dad used to say, a good prosecutor could indict a ham sandwich. So an indictment means nothing.
Exactly. But not in the jury's mind. They think grand jury has indicted them. The presumption of innocence is gone.
Well, this is why I said this is a media issue that has played in, and it's why they handle cases the way they do. And many people believe the police showed up, they arrested him. Listen, the perp walk is not just for entertainment.
Have something to arrest him.
The perp walk is solely meant to tap away at the presumption of innocence and make the person look guilty and make the potential jurors assume the police wouldn't be parading him in front of the cameras in handcuffs, walking him into the courtroom if they didn't have really good evidence. And that's the wrong thing, because the discussion, again, listen, part of the whole idea here is behind justice as a process is one of the things that's saying that my dad used to say, justice is a process, not an outcome. And the biggest problem with the criminal justice system is everybody's focused on the outcome and they think that's justice. That's not justice. Justice is not the outcome. Justice is not sending someone to prison, and justice is not acquitting someone. Justice is that a fair process occurred and the rights were respected of everybody, the victim, the defendants, and everybody that's involved in that process, from the police to the prosecution to the defense to the judges, that they're all fair and they follow the Constitution and they follow the process, and they don't be afraid of the outcome, because the outcome is not what they're supposed to be worried about. But the problem we have is we have prosecutors that are only worried about the outcome, winning. We have defense attorneys who, well, really, they're always gonna. I mean, if they're doing their job right, then they're going to be doing the right thing, which is asking questions and questioning the state's case. But when we have plea bargains, that's not the right thing to do. The plea bargain system is the single most terrible thing that's going on in our criminal justice system, because what it does is, when the police make mistakes, the natural way our system is supposed to take care of it is the case gets thrown out, right? If the state or if the police don't follow don't have a warrant, right? They get a warrantless search. Well, what happens a lot of times is the prosecution will plead that case out and they'll give a really sweet deal. And you may think, oh, well, that's just because, boy, that's a really good prosecutor. What a nice guy. He's giving him a great deal. No, what he doesn't want is he doesn't want the judge to rule on that. He doesn't want it to become part of case law. He doesn't want it to be established that this happened. So what happens is the warrantless search never gets addressed. That issue never goes before. There's no case established on it, and it goes bye away. And on top of that, one of the things that people don't realize,
that's why Ty wouldn't take the plea deal.
One of the reasons, absolutely.
Why should he? He's innocent.
But to answer your question about the bar, the reason why is because it's not politically, it's not a politically friendly thing to suggest that we should raise the bar to get a case charged. Remember, we have a media right now who wants to take away everything from someone who's just getting accused in a civil lawsuit. Okay? Never proven in court, never been put through the test, never been able to be questioned. Because remember, part of the trial process is testimony is evidence. So that's one of the things that when people say there's no evidence against Ty, there is. There's John Travis Johnson's testimony, which is evidence, even if it's false. But that testimony should be put forth before a tribunal, and it should be examined, and it should be questioned.
He recanted, didn't he?
Well, he didn't really recant. What he did was this. He filed a motion to suppress through his attorney, and his attorney alleged that the statement that he gave Captain Phelps was coerced, and that it was coerced through using the Reed technique, and that it was implanted, and that it was not true, and that he was innocent. Essentially, he asserted his innocence.
There was a statement made of that.
Well, there was a motion filed. The motion was never contested. It was when that motion was filed, before hearing was ever set, and before anything was ever done with it, that the plea bargain was offered that said, if you agree to testify, we will let you out of jail in 30 days. And you will get time served. And as long as you comply and tell the truth, air quotes, then this agreement will be in effect. But if you fail to tell the truth, air quotes, then you get 30 years in prison.
So can Ty bring in that statement of his?
Well, that was the issue, that yes, he can, and there's a hearsay exception to it. It's a business records exception. In other words,
he has to take the stand.
Well, he doesn't have to take the stand, but the clerk.
John Travis Johnson does, doesn't he?
Well, John Travis Johnson does.
Yeah.
He has to then testify differently than what was inside that document.
Yeah.
And then Ty has to bring in, or has the right to bring in, the clerk of court who can substantiate that was a document used, basically filed in court, used in the course of business. And then he can question John Travis Johnson and essentially say, review this. Did this come in? Now, not the entire motion can't just come in,
No,
but
but it's a
it's got
good
to be
way of
it's got to be
getting at his
fleshed out.
credibility.
The parts of it is he can be confronted with it and saying, "Did your attorney file this on your behalf?" Yes, and you understood that your attorney was alleging that Captain Phelps, uh, coerced you into saying
Mm-hmm.
X, Y, and Z, which is contained in this motion. And isn't that exactly? And you testified earlier today on direct X, Y, and Z, correct?
Mm-hmm.
So the very testimony you just gave this court and stood before this court uh, was your own attorney, with your knowledge, said it was coerced. Is that correct? And it was only when the state came to you and said, "We'll give you a plea bargain," if I'm understanding things, that you decided to retract that motion and take a plea and have your case dismissed. Is that correct? All right. So I want to be clear, Mr.
Yes or
Johnson.
no, Mr. Johnson?
Well, and that's the point of cross examination. See, what
Yeah.
Ty did is he let John Travis Johnson
He let
talk
him.
and talk and
Mm-hmm.
talk
Yes.
and talk. And what you're
Yes.
supposed to do on cross is you ask yes or no questions,
Yes.
and you're doing the talking, and they're saying yes
Mm-hmm.
or no.
Yeah.
And then on redirect, which normally there is no recross, there's redirect, and then that's it. Unless there's a special circumstance that opens up on redirect that you get to get into, as long as, like, basically, if the prosecutor opens up a new can of worms on redirect, then you get a
Okay.
chance at
It's been
recross, but it's
expanded.
very limited scope.
Yeah.
Now, Judge Jones was like loving it because it was like, hell yeah, we'll let this guy just go away because he thinks he's helping his case, but he's just
Mm-hmm.
letting John Travis Johnson talk and talk and talk,
Mm-hmm.
and it wasn't coming across to the jury. But that's what Ty's got to get better at. Now, Ty
Mm-hmm.
acknowledged that.
Objection non-responsive.
Well, he acknowledged, to me at least, that he really wasn't very familiar with how to question witnesses. But now he's
No.
become more
Practice
proficient with
run.
it.
Yeah.
He's talked to attorneys about
Yeah.
it, and he's now ready, much more
Good.
prepared, he believes, to handle that. But that's what you got to do. You got to walk them down with the answer in your question, telling the jury a
Yeah.
story.
You never ask a question you don't know the answer to, and he did
Yep.
ask many questions that he didn't know the answer to.
Yep. Correct. Well,
What was Flash saying? Can you
Well, he
get
says
that
if I was
writing?
him, I would have the motion to strike all the narrative that Johnson was providing. Well, here's the problem, Flash fan. He was inviting it by his questioning. So that would be a problem. Now, some of the things he could ask, if it was, depending on what was said, he could ask it be stricken. But but a viable response from the state is he opened the door. In other
Yeah.
words, if
Can't
Ty
undo that.
asks the question that prompts the narrative, Ty opens the door, and
Yeah.
then he has a right to say what he's saying because
Yep.
Ty essentially waives. Again, this is where Ty runs into problems. Is he's got to know the law, and he's got to know what the law's there to protect you, right? It's there to make sure that hearsay doesn't get in. Why is hearsay important not to come in? Because hearsay is basically indirect things that were said
Mm-hmm.
that were not said, that are essentially being stated for purposes of truth, and the court doesn't allow that. You've got to be stating it from your own perspective, what you heard, what you saw, but you cannot be discussing what someone told you they saw. That's for them to testify to, not you. So those protections are there. Now, Ty's kind of like the guy, the quintessential person who says, well, it's the fool, that says, well, I'm innocent, so why should that matter? Well, it matters because when you get a good defense attorney or a good prosecutor, they know how to argue these things, and when that stuff comes in, and the jury is only meant to be considering the testimony that's being presented to them in
And the
that moment,
facts.
in the facts, and it's only then. That's why they can't. That's why the prior consistent statements aren't allowed to come in. You can't bring in police statements that match the testimony. It's the testimony that day on the reflections of whatever they saw or heard, and the jury is to then give it the weight they believe it deserves. And they are to evaluate it based on how the court tells them to evaluate testimony. Is there a motivation to lie? Is there inconsistencies? They can consider some of it, all of it, or none of it at all, and they get to decide what that is and how much they're going to consider or what they're going to take out of it. But it's the testimony in that seat in that moment at that time. Now, if they're lying, the opposing party has a right to bring a prior inconsistent statement and confront them with it and say, you said this on this day, and you're saying this today, and explain that to the jury. Why are you saying it? Is it because you're lying? Is it because of this? Is there, and then the jury now gets to understand that they said X on this day and they said X on this day, and the jury gets to apply the weight to it. They get to decide whether they,
but it all attributes to doubt.
But at the end of the day, if the jury can't decide something, in other words, if they say, well, there's these two statements, we don't know if it means he's guilty or innocent. The law is very clear. That's where the presumption of innocence kicks in and says you break in the favor of the defendant. And too many times, defense attorneys themselves, as my dad used to say, there's a reason why defense attorneys don't come and argue it properly and don't use it the way they're supposed to, is because they don't really understand it themselves.
But they don't have the burden either.
Well, they don't have the burden, but they want to make sure you shift the burden where it needs to be shifted. And you want to make sure you can explain to the jury and how to apply that and how to review the case. Because, again, it's very powerful. Like, the presumption of innocence is the most powerful thing. Listen, believe it or not, it is the thing that makes our justice system special. It is the single most, there's no other system of justice that has it. Okay, it's the single most unique thing that is there. But it's the thing that the government hates, the prosecution hates, because it's in all other jurisdictions, all other places around the world. You got to just prove a negative essentially to try to get acquitted. In America, no. The state has to prove a negative beyond a reasonable doubt, if even one scintilla of that. And again, that's what our founding fathers said. The right to freedom, inalienable rights to freedom, the ability to be free is so important that you have to have 12 people come in. You have to have them review the case, and all 12 have to be convinced beyond any reason, beyond a reasonable doubt, not all doubt, but beyond all reasonable doubt, all doubts that reside in a reasonable person's mind, that the state possesses evidence that the law was violated, and then they can be punished, and then they can have their liberties taken away, and then they can go to prison. But even when they go to prison, one of the things we have to remember is we're still supposed to protect them against cruel and unusual punishment. So that does not mean we send them to a barbaric prison like the Metropolitan Detention Center, or down to prisons that don't have adequate air conditioning or adequate heat. Okay, that's not what we do. It's not what we're supposed to be doing. And again, as every society should be defined by how you treat the worst, right? And that's truly how it is. So,
Florida.
Not in Florida. Well, not unfortunately, as it's becoming more prevalent around the country. People are, again, a lot of people don't understand the precious thing that they have as having the presumption of innocence in their corner, and people shirk it off and say, "Well, if I'm innocent, I don't need it." Oh, you do.
Well, I think that's what Ty got hung up on, was trying to prove his innocence instead of focusing on creating the doubt, because there was nothing there.
Well, and I think that's what everyone that's a lawyer or has any legal background got frustrated about is that if he had a competent, strong attorney, this case goes bye-bye
5 minutes.
In 5 minutes, right?
Yep.
It's going to get taken care of.
Yep.
And the problem with Ty is he doesn't want to, he wants to bring in all the stuff.
Yeah. Yeah.
And that's really, and that's not necessarily going to get him
fights. Just focus on you and take that up later.
Well, exactly. That's what the civil. Listen, remember in the last live we were talking about it.
Yeah.
He's got like 3 civil.
Still focused on all of that. He needs to just direct his focus on the one thing first.
Well, his other attorneys, the attorneys he fired, they're still involved in 3 civil actions for him, but they're waiting to see how the criminal action goes. And that's why I found it crazy that if I'm sitting there and I think I have 3 viable civil cases that's dependent upon winning this case, and this is a case that should have solid media coverage if it's handled correctly.
Mm-hmm.
Why in the hell would you not want to be involved in the case in representing Ty? Now, I think,
Mm-hmm.
unfortunately, Ty, I don't think is very open to it, and I think that's just part of the problem. I think he wants his case done a certain way, and there's not going to be any way to convince Ty of
Well,
that.
the
But
only way I think he said he'd be convinced is if he actually did get granted the motion for change of venue up to Miami-Dade, and then he gets a completely new judge, new DA,
yeah,
and then possibly new attorney. He said
yeah,
that's
but
when he would consider.
now, Jody, let me just tell you, I have been around pro
Is
se
that not a?
defendants.
Oh.
Unfortunately, here's the problem. It's like the gambling effect, right? The gambler says, if I get the big win, I'm
I
leaving
won't
the
do it again.
I'm
Yeah.
leaving the casino. I'm going home, right? And then they get the big win. And
Mm-hmm.
then they get the adrenaline rush of the big win. And then they're like, "Oh, I'm going to hand the reins over." I mean, I just won this venue, change of venue. If I can win the change of venue, I can most certainly win a trial. So,
Well, he's hoping it just gets acquitted, being
and
seen by another set of eyes.
well, not only that, but it's also, I think, too, you've got to understand, too, from a perspective of when you get it, when he gets involved in this, it's like, you know, there's also an idea that if he were to, at this point, he's emotionally involved in this as well. I mean, these are
Of
people that have
course. Of
taken
course.
7 years of his life, and
Yeah.
he says, I want
And
to
he's been in
beat.
jail for 2.5 for nothing.
Well, in the thing, yeah, but I think in his mind, what better way to shame them than for a pro se defendant to
Hmm.
come into court and kick their ass? Of course, it's easier said than done. But in his mind, and as he's looked at the case, and it is not a very strong case. I mean, if it's a case that a pro se
Hmm.
defendant can win, it's this one.
It's a bit
But
ego driven, you think, perhaps.
well, I think to me it's easy. It's an easy case that I don't even like. I said, listen, he doesn't need anything else. He doesn't
Yeah.
like he literally does not need.
Mm.
He's got everything he needs to win the case, and
Keep it simple, straight.
let this thing go to bring it in. They bring it in. I mean, what are they going to do? They're going to bring it in. I mean, I've rewatched. Well, you rewatched it. I know I recently ran it, and I was rewatching it. I mean, well, the case should have been done in like 3 days, but he
Yes.
wanted to bring in like Paula, and that was a backfire. I mean, he didn't need her
Mm.
in there,
Mm.
but because again, remember, if you focus on what it's really all about, what's it really all about? It's about
Mm-hmm.
the state's case. It's not about Ty. It's not about Ty proving his innocence. That's not.
Yes.
That's not what it's
Exactly
about.
right.
Um, he does have an arrogance about him, but again, I think some of his arrogance is I think he's also just pissed off.
Well, wouldn't you be?
But I also think he wants to prove people wrong. Like I think
Yeah.
now he's got a chip on his shoulder. I mean, listen, I firmly believe that what occurred in August of 2023 is I think that Lauren told him, Ty, you know, we either win this motion, or meaning the motion to dismiss, or you take the plea because I'm not spending any more money on the case. And then he didn't win the motion to dismiss. And then I know his attorneys wanted him to take the plea. I think she probably, just because it was costing a lot of money. So I think what happens is he says, I'm going to prove you all wrong, and I'm going pro se then. And, while yes, I think he also wanted to, do other, there were some other noble ideas, but I think the underlying driving idea was like, I'm going to prove you wrong. I'm going to prove all of you wrong. I can handle it on my own. It's kind of like, like the 13-year-old kid where everybody's like, we're going to play tough love on you. And then he's like, I'm going to prove all y'all wrong. Like, I'm going to go out and do this and I'm going to win. And he does, he goes out and he has success. He gets a mistrial. He gets a hung jury. And now it's like again, I've watched this occur over the years with people my dad helped out, because one of the things was my dad would help people out to try to help cut down their legal bills to help them file certain motions and things. But then at a certain point, they were supposed to then hire an attorney. And it was attorneys that my dad was affiliated with who understood what my dad was doing. And they would factor in the fact that my dad helped these people put together a good running start on their case.
And you get
So,
full of confidence and all cocky.
and they were very, very confident that, about the motions my dad would file. So it was like the attorney just had to show up and argue the case, and then it would go well. But then all of a sudden, some of these people would make some court appearances, and the judges or people would be impressed with the documents they're filing. These people would lose track of the fact that they didn't file them themselves, but they start thinking they're like Perry Mason Jr. And ultimately, that ended up resulting in my dad being charged with unlicensed practice of law, and it resulted in a second trial for him. And I helped him with that case, and we had to go fight it because there was 11 people that he was helping that the state police came after. Now, they were coming after my dad because they wanted to keep him from getting his law license back. But the point is, these 11 people got caught up, and they shouldn't have been representing themselves anymore. And they brought attention to themselves, and it ended up essentially costing my dad the ability to ever get his law license back. And they found him guilty of unlicensed practice of law after a lengthy trial, and it was and then we appealed it all the way to the United States Supreme Court, and it was not found in his favor. But the point of the matter is that Ty is just like those other people. He goes in, he gets a little taste of success, and in his case, I mean, he got a taste of success that, like, those people, that was small potatoes. This was just some people around the courthouse that were saying, great job. Ty got court TV telling him, great job. Law and Crime telling him, great job. He has a legion of, well, it's a small legion, but it's a group of YouTubers that have coalesced around him and said, we believe in your innocence. So it's going to be hard to push him off the case. I mean,
do you think he's got a good chance of winning this motion for change of venue or not?
I mean, I think the change of venue, yes. I think as long as he can, in the current conditions that he has, see, a lot of these things when you get up there, and this is what I think he's really worried about is one of the basis for turning down appeals or turning down a motion like a change of venue motion is you've got to have a certain form, and you've got to have a certain length, and you've got to have a certain time frame that you get it in. And if those aren't met,
you got to meet the criteria of reasons why.
Well, the law is very clear. You waived it, right? And that's it. It's done. And in his case, I think what he's really afraid of right now, which is why he called me today and why we're trying to drum up some people to make sure that they know, hey, he's got stuff coming. It's on the way. But he's concerned that somebody could have looked at this handwritten thing and said, what is this? This doesn't meet our standard. Chucked it. And because there's not the ability for him to communicate or them to necessarily, again, you might think, oh, everybody's going to know who Ty Tucker's case is. Some clerk down at the DCA, third DCA, doesn't know that. He just is like, what is this? And throws it away and thinks it's spurious. And Judge Morgan isn't going to help him get it filed. Joe Mansfield isn't going to help him get it filed. But again, this is why, at the end of the day, why Ty should be having, figuring out some way to get counsel involved, because I can't help but think that there isn't a way to get counsel involved at this point, even if he drops him before trial, if trial has to happen. I mean, he could fire him at any time. I mean, you saw Sarah Boone went through like 11 attorneys. So to me, it's like, I mean, to me, I think it's like, why not fuck with them like that? I mean, and just keep them all coming in. But I think there's
use them for picking their brains and put it to use.
I think there's a certain amount of ego there that's getting in the way. That he wants to be able to say, I did this on my own. And he's got certain, and he didn't do it all. I mean, he wants to say, I did it on my own with people's help, with supporters like us. And it's a cool story. And he's willing to gamble his whole life on it. So much respect there. But it's concerning if it doesn't work. And for us, it's like we have a story to tell people. Hey, we were involved in this case, and bringing attention to it.
Yeah, but we don't have our lives on the line at the end of the day. We can go home.
we're not sitting in 105-degree Georgia or Florida heat serving a life sentence, or in 30 or in 30-degree temperatures when there's no heat either, in terrible conditions.
But
That
what lengths would you go to if you were innocent as well? Like,
well, I mean,
you got
listen, if
7
I
seconds
was,
to end. You limited.
oh no, it does that for
Oh,
whatever reason. No,
oh.
we have 8 hours. So I mean, what lengths would I go to?
Like,
Yeah,
you're innocent, and
yeah. I
you've
mean,
been put into this corner.
well, I would.
Would you have taken the deal?
Well, no, I probably
No.
wouldn't have. Although, although it would have, it would have had to see how the deal was structured. I mean, I guess I'd have to look at
Mm,
the current scenario of like what are the implications and ramifications of the deal in terms of, there also has to be an acknowledgement of the ability to fight and the ability to properly fight this thing. Now,
mm,
would I take in the deal? No. But what I would be trying to do is figure out a way to drum up support for an attorney, and I would be
an
very,
outside attorney.
and I would be trying to do everything I could to try to, just keep as
Mm,
much pressure on the system as I can,
yep.
keep
Yep.
them working. But I mean, at the same point, I would be wanting to make sure I got a decent attorney, and I'd have no problem firing the attorney, knowing that if I can't find a good attorney, and again, I know he's going to come back and say, "Well, I went through all these attorneys." Hey, listen,
So he could
but
use an attorney right up till the day before trial, and then fire them, and then defend himself.
and that's what I was trying to get across to him, was I was saying, if
Ah,
he gets,
okay.
listen, if he got an attorney right now, we would all be able to contact that attorney. We would be able to keep that attorney honest. We would
Yep.
be a place for that attorney to come on
Put
and talk
pressure on
to.
them. Yep.
Well, and talk to us and have discussions. I mean, look at Rashbaum. He was on before he got kicked off the Adelson case. He was on Surviving the Survivor, talking to them about case and strategy. I mean, there's limits to what they can talk about, but they're on there getting their 5 minutes of fame, and coming on and talking about things. So there's a lot that can be done. There's a place that we can all be contacting and working with and briefing them on, and making sure that they're doing what they're supposed to be doing. And again, if he doesn't like what they're doing, fire him. I
Mm,
mean, that's, to me, it's spend the state's money. I mean, it's
yeah.
money that the state's going to spend.
Yep.
And if at the end of the day, if Ty is really comfortable representing himself, who cares then, right? You just keep using it, because you know what? You might find that young kid who takes a look at this case.
And they can do work for you that you can't get to.
Oh, absolutely.
Take some of the pressure off.
But if they don't, but again, if they don't do the work, if they ignore you, if they're not doing stuff, then get rid of it.
Mm-hmm.
So, well, yeah, Flash fan, I know, and I know Vinny said they
Yeah.
were on it, but the other
Yeah. No.
night, it was quite disappointing, because Vinny, I guess, Scars went into Vinny and sent him a
Under
super
yourself.
chat
Yeah.
and said, "Under your scars," and said something to the effect of, Ty Tucker's case is coming soon. He needs your help. He needs you on it. Contact justice is a process. And Vinny looked at it and said, well, it appears, yeah, Ty Tucker, that's one of Diddy's accusers. I believe he was someone who filed a civil suit against Diddy.
Ba-boom.
And I was like, Vinny, what the hell?
Mm-hmm.
So, I mean, I don't know that Court TV's on anything at this point. I
No,
mean,
wait until the
if
hype
they were, listen,
comes up just before trial.
if they were on it, there's enough juicy material right now
Oh,
that they should be reporting on this every day.
that's what
I
I
mean,
said. Karen
um,
Reid, exactly the same.
well, I mean, just everything that's happened. His bond got
Mm-hmm.
revoked.
Yep.
He's had all these evidentiary hearings. He's now
Yep.
filing to go to the third DCA. But so I am absolutely not at all convinced that Court TV is anywhere near this thing. And when Vinny did that, I was appalled, because Under Your Scars sent me a link to the live. And it was It was on the Diddy arrest, and she sent it to me with screenshots and timestamps, and I went
Mm-hmm.
in and I was just like, are you shitting me right now? I mean, I should snap it into a damn short and embarrass
Yeah.
him because
Yeah, you should.
it's really just appalling that I mean, it showed two things. He don't know shit about Todd Tucker's case, number one, and number two, he
And
don't know
doesn't give a
shit,
shit.
and he doesn't know shit about Diddy's case apparently. If he thinks someone named Tyrone, and then it
If he
also,
really cared, he'd remember.
well, I mean, the idea that he must have thought that he must have been thinking Tyrone Tucker was Little Rod
Oh, I
because
don't know. I don't know the
he
Diddy case.
because that was the only male I know of that filed a lawsuit. But I mean, talk about just being unprepared and not knowing what the hell's going on. That was a prime example. But so listen, I hope somebody picks it up. I mean, this case, I can't believe someone isn't. It's one hell
Yeah.
of an interesting case. I mean,
Am
it's
I
got.
able to share a screen? I've got all of the
Oh
of
yeah,
Ty Tucker's contact
you should be.
details.
You should be able to. Is it
I'll
up?
pop it up.
Wait a minute. Oh, hold on. Yep,
Oh,
there it is. Yep, put her up.
how do I zoom that in? Can people
Hold
see
on.
that?
Oh no, I can hold on a second here. I can help us with this.
So it's got
And there it is.
his case file number at the top there. If you go into the Monroe County Clerk's office, his MNI number, his ID number and booking reference number, his website, his Facebook link, his YouTube link. I forgot to get his merch link. Gabby's got that. And the actual the correct postal details on where to send it and what you have to put on the envelope. Otherwise, it won't get to him. So it's got to have his full name and ID number, and you have to have your full name and address on it so that it meets their criteria. Otherwise, they won't pass it on.
Gotcha.
Everyone got that? Take it down, or?
All right, I will take
What do you
her
reckon?
down. Hold on a second. Get us back. I'm doing some little before it
Oh, look
comes
at you.
down. Yeah. So you can do this before it shows up live, and then that way we can get restored. And then now there it is. Boom, we're back. I should have done that before. I didn't think about it, but yeah. Well, recovery addict. Again, like I said, I mean, that's our hope is that somebody like that. And listen, Vinny might still wake up and realize Ty Tucker is not one of Diddy's victims. I mean, I don't know that. I mean, I think Ty probably is a little outraged at that because I don't think he wants to be all associated with that mess. But, um, uh, you know, there's hope there. I mean, we need to all go in and communicate with, do what we can to communicate. But I don't know that Vinny is. He when I gave my $10 super chat, he said he was going to be doing
Mm-hmm.
something, but I think the other thing we need to make sure we do too is put Franklin. Anytime we're talking about it, put in Franklin Tyrone Tucker treehouse case, and then he will know exactly what you're talking about. Don't go put Tyrone Tucker in because he will not know what you're talking about. And that's not helpful. And it's a waste, especially if you're spending money to try to get his attention. I mean, I feel terrible that was wasted because,
Well, it's sad that it took that to be able to be heard.
Well, I know Flash Fan's been over there doing a
Yeah,
lot
he
of
has. Yep.
advocating, and I know I wasn't the first one that threw a super chat his way, but it's what we end up having to have. But there's other ones out there too. I mean, listen, if Lawyer would take this on,
I have tried to contact him on X, and I have
well,
sent
it's
little snippets of things to him. But
if Bruce Rivers would look
he's
into it.
great, isn't he?
Oh, I love Bruce Rivers.
Yeah.
And my dad loved Bruce Rivers. We used to watch him together. That would be great if he would look into it or just watch something about it. But again, it's limited in what these guys can do outside of YouTube. I mean, what we really need is someone like Court TV, excuse me, to just give that coverage, that round the clock coverage. that we need of this when something's happened. Look, they were doing it. If you would go back and look at the very last thing that they did. Hold on a second here. Let's
I've
go back.
actually been watching a criminal defense attorney who's in Florida, and he basically does these little snippets in his car on his way to or from work, and basically addresses a lot of the issues that he has down there with corruption and prosecution and judges and the whole lot. And the last one I watched, I can share it later if you like, but yeah, it was basically he was driving along and there was a Corvette and I think it was a Monaro or something like that. And the Corvette did the whole, street draggy thing to get the other guy to race him. And as soon as the other guy put his foot down to race him, the Corvette, beep, 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 red and blue, and basically entrapped him. And while he was driving to work. So, but yeah, he's down there, and he'd be a good one to maybe get the story.
Absolutely.
To.
Well, I mean, it's very possible that Vinny Politan investigates. I mean, that is his show that he has that does the investigations. I mean, maybe he's investigating it as we speak. I mean, that would be fantastic. So, I mean, don't give up.
Journalist, yeah.
I wouldn't give up hope. I wouldn't necessarily stop bringing it up because I think that it's going to cause them to have to look into these things. And I hope.
I'll just keep posting it on their Twitter feeds.
Yep, you just got to keep posting it on the Twitter feeds. Go into their shows and put up.
That's where all the YouTube creators.
Yep.
Congregate.
And just continue to try to advocate for Ty and do. Yep. That's all we can do. I mean, and then like I said, at the end of the day, I think it's all got to be very clear, and Ty knows this. Is that
it's like that, isn't it?
A jury, yeah, it is.
It's getting late for you, is it?
It is. It is.
What time is it?
1:00 in the morning.
Oh dear! I got to bed at 6 a.m. this morning, and up again at 10.
Wow,
that's dedication for you.
Yes, it is. But he's
hence the M&Ms.
But I think he's got to. I think he knows that 12 jurors are going to have to free him from this unless he wants to take the plea. Which I don't even know that the plea still would even be available if that was, so. Or I guess it's 1:30. Holy cow. Yeah, it's 1:30. Sorry, I didn't even know that, Flash fan. My
did the Carly Bread thing still, thinking that it was going to go to verdict. Watch tonight, last night, but.
Yeah, that'll be tomorrow morning. They're gonna do closing arguments tomorrow, and then
scream at midnight tonight. Yay for me!
And rest assured, Jody, there will be. I'm quite certain there's going to be a verdict tomorrow.
Oh, I reckon it'll be back within 2 hours max.
I think. I don't know. I think that it might take a little longer than that, but I think it'll be back
I
by.
need to go to bed.
I think it'll be back by.
Well, he's sequestered them, hasn't he?
Well, he will be, and it's coming up on a weekend, so it's kind of like they'll be back. I will say they'll be back by 7:00 tomorrow night. I don't think they're going to want to hang around too long.
Which is what 9 a.m. I'm not doing it.
Well, I mean, I think at that point, honestly, you can get up in the morning, and if you have to, and the verdict comes in, you'll be able to give some, go live and replay it for everybody because everybody loves to watch a verdict. That's a fun thing.
Yeah, no, AJ wants to do it live, so. Do they do the closings and then the jury instructions, or is it the other way around?
Every state's different. Most states will do the jury instructions last. That's I'm not sure if Tennessee. I'm trying to think back because I covered the case with David Swift. And I'm trying to think if they did. I think they did the jury instructions last. So I believe the state or the jury, they're going to do the closing arguments, and then the final thing the jury will hear before they go back is the instructions from the judge. But obviously, listen, don't sleep on the jury instructions are what they're going to. I mean, as my dad said, two places you win a trial, and voir dire and jury instructions. And what's more important the most important part is the jury instructions.
That's how what failed Karen Reid.
Well, they make or break. Mm-hmm. They can make or break you because certain instructions will. Sorry. Yeah. It is Mississippi. I don't know what you're right. I guess I got confused. I think because I heard testimony about the Rockies. That I think they went to Gatlinburg, I believe. That was one of their vacation spots where they met or something. I remember hearing about that. But yeah, so I'm not certain that I really am not, because I don't think I've covered any cases in Mississippi at all. Let me see if
you need to go to bed.
Let me see if old Google has that answer. In Mississippi are
if you're not doing anything, you can pop in and say hi and jump on the stream for the verdict watch while we're going. We need something to entertain ourselves.
Well, actually, it's funny because tomorrow I'll have the opportunity to do that because I'll be here watching the baby as long as the baby cooperates, because Sir Connor will be at pre-K and my wife has a funeral to go to tomorrow. So I will be on baby duty until about 2 p.m.
We're going live at 12, and I reckon at least 2 hours for closings, and then 45 to an hour for jury instructions, and then from then on it'll be verdict watch.
They are read before. So so when it will open up with jury instructions, and then they will close, and then the jury will get dismissed.
Okay.
And then there will be potentially instructions following closing arguments if there's any omissions or if there's any things that need to be added based on closing arguments. So there could, but it won't be a lot of instructions. The majority,
under sequestration.
Yeah, the lion's share of the instructions will be given. Yeah. And there may not even be anything else that follows, but
hopefully not.
Yep. So.
All right. Well, I'll get AJ to send you the link, and you can just pop on whenever you like.
Yeah, absolutely. And then it's I'll be able to pop on, provided that Sir Carson allows me. Although he might be there, I think I actually figured out that
sing to him.
Well, I figured out that I can hold him. Like if I'm holding him in my lap right now, he is not seen on camera. He's just kind of perfectly right here. So it's only if he were to decide to exercise his lungs and make his presence known.
Just mute yourself.
Well, he loves to sit here because I've got lights and stuff. So he looks all around and loves it. It's actually a place I take him to calm him down. He very much enjoys it. So, but yeah, so I think on that note, though, I think we'll go ahead and close this thing out, Jody. I guess you probably need
back to bed. I think
I was gonna say you probably need to take a nap, and that will cure
sleep all day.
I was gonna say that will cure the issue of how late it's got to be if you go to sleep and
if jury instructions are first, I don't think AJ wants to watch them, so we might even be starting later.
Oh, I gotcha. Well, see, now that's a mistake because you want to watch them, because if you guys are going to try to give any type of opinion, that is a big, big mistake, because again, that would be, where a verdict comes down and everyone in the room's going, my God, how did this happen? Well,
to understand
in order to understand it. And right now, that jury, you've heard all this evidence. You guys have sat and watched
that, aren't they?
You sat and watched all this entire trial. The judge now is going to tell you how to decide it. So then you guys can deliberate. We can all deliberate. So you got to watch. Got to watch. Got to watch. I mean, even if she doesn't want to, you just man the stream and start it up. And
we take it in turns on who hosts it, and it's AJ's.
Turn them on
tonight, so I don't have to do anything. I can't even bring up chat or anything. So I just sit here and laugh.
I got you.
No responsibilities for me tonight.
So there's no ability to cross control or anything like that.
No.
Gotcha. Well, like I said, that's something that I know it can seem boring, but it's actually, I love the jury.
40 pages long.
Well, let me tell you, man, you can do 3 shows on a jury instructions if you get them down. I mean, that was the Crumley case, man. That was some great stuff, because it was the jury instructions and how they had to deliberate. And that's, if you understood how the deliberations were supposed to go, you understood why they should be found not guilty, because it was crazy the way they were trying to apply it. But then when you heard how the jury deliberated and what they found to be relevant information that factored into their verdict, you understood that that jury went rogue. They didn't follow the law. But
I know AJ wants to pick your brain about Zachariah Anderson too.
Yeah, well, and that's a case that unfortunately I don't have a whole lot of experience with. I know it's
just the law aspect of some of it.
Okay, yeah, but it's one I want to check out because it's one I know that a lot of YouTubers have jumped in. So maybe during one of these,
we're thinking about over maybe Christmas when it's
Well, I was going to say basically from 2 weeks before Christmas to about, I'd say, the end of January. That would be a great one that we could get together and just be like, hey, let's watch this case and see, because I literally am a blank slate on that. And
me too.
I've heard about it. In fact, I mean, I'll be honest with you, I thought the guy was like guilty. I mean, and then all of a sudden everyone's saying he's like the poster child for, wrongfully accused. And I'm like, oh, I mean, but the basis of that was literally just the way everything was like presented in the media, and just the look of it was like, oh, I thought it was. Then the jury found him guilty. Turns out, I know
the opinions that I've heard, you're either one way or the other. It's not a gray area.
Well, I know there's a legion of people that think he's innocent. So listen, I'd love to be able to sit and, but again,
we could maybe watch the whole trial again. And
what we have to, I mean, we got to go through it and delve into it and dig into it and say, okay, let's see where we stand on it. But I think but I don't want to go do research on it too much because to me, I haven't done it in a while, but I like to sit down a lot of times when I'm sitting in like when I sit and watch a trial, which I haven't done since March.
We're going to do it as a jury member.
Well, that's my goal. When I first started out doing this, it was like my goal, my vision was to be able to do that and like take on a trial and watch it and then do shows and put out content all around that trial and what was happening. And then, it's obviously just lots of stuff's going on. I lost the monetization briefly. So I haven't really had a chance to really be able to say, let me put the time in and find that case to do it. But that's why it's like, I never want to, when I am going to do that, I don't want to know anything about the case. Because I want to be that, like the jury doesn't know about a case. So when I come in for closing arguments, it's like, all right, teach me about it. Like, tell me about it. And I'm not going to go dig. I'm not going to go investigate. Yes, Flash Fan, I was streaming some classic trials. Like I said, that was going on, in that was back in the summertime. I'm still going to try to do that. That's the Justice Watch channel, my secondary channel. I've kind of reserved that for the classic trials. So my goal is to still do stuff with that. It's just a matter of, there's been so many daggone current trials right now.
I know.
And unfortunately I am actually like just a common everyday person. So I do not have a streaming farm at my house, and I do have teenagers that are also playing video games. So we kind of get in a war over bandwidth and stuff, where I can only have so much running at one time. Well, it's true. Like if I try to run too much, one of them will start stuttering or slowing down or freezing up. And then it's like, I just wasted all this time. So then I got, it's just a lot, but I look forward to, the next one I'm looking forward to right now, is the Sarah Boone case.
I reckon that'll be 2-3 days max.
Yep. Well, it's going to be good. I'm going to be.
It's going to be wham bam. Thank you, ma'am.
Well, that's the one that I am extremely interested in. I'm going to probably try to carve out some time when that trial hits, especially since it's on my own time, 9 to 5.
They've set a date, haven't they?
Oh yeah, it's a hard, fast date. Kind of like Ty's was, where the judge is.
Is it October?
I think it's October 5th. I want to say. And then they're coming up on that, and that attorney I was asking for a continuance, and the judge said, "Nope, you're going to trial." So that one's going to be an interesting one because she's claiming self-defense. They turned down the battered spouse, or maybe I think it's going to be similar to.
Sarah Boone's claiming self-defense.
Well, yeah, basically. Well, essentially, the theory of it is that he was abusive to her, and believe it or not, there's a wealth of police calls, and there's several that have come out. There's one or a couple that came out that somebody got their hands on, but essentially, they have an expert that's going to come in and testify that the mind of a battered individual, even though she's not getting physically battered at that moment, that when she was doing what she was doing, it was colored by that experience. And
have that turn out to Ashley Banfield.
Well, in that subconsciously, what they're going to say is they were doing this game. He's getting mad, right? Okay. He's locked in his suitcase, and she's afraid to let him out. Because if she lets him out, he's going to beat the hell out of her. And that's what he's done in the past. So, again, that's why I want to sit and watch the case. But but from listening to the pretrial hearings and what the jury's doing, which again is kind of obviously, colored my mind a bit. But I've been following that case ever since it came out. That was before I even was on doing a YouTube deal. But that to me is going to be an extremely interesting case to see how it goes. I thought her interrogation was so interesting because she was the only one in the room that didn't know she was going to jail.
Yeah.
So it'll be interesting. It's going to be similar to Banfield, where like they didn't get the full battered spouse, but they're going to still argue it anyways. And she has a history of being, because they're not married technically, so there's like parts of it, and but she's going to argue that essentially her past experiences led to the mindset that led her to not let him out of the suitcase. And I have a feeling it's going to go along the route of he was upset or mad, and she was like, "I'm not letting you out because if I do, you're going to beat the hell out of me." And then, I don't know, man. That's a pretty brutal situation. Like, how horrible. But the first question I have is, why the hell would you get in a suitcase?
Yeah. What adult plays hide and seek to get into a suitcase, for goodness sake?
Like what type of ridiculous thought process led you there?
Yeah.
And then
that's what I said.
I would never do that ever. Like, period. So, there's a lot of factors. That's why I say it's not as clear cut, I think, as many people think, because there is the part of him getting in. So if he wasn't coerced into the suitcase, and see, this is what the defense attorney is going to argue. He wasn't
on his own free will.
If this was a scenario where he was coerced in by her and they could show that, okay, but it's not. He got in on his own volition, and as Flash Fan said, they were drunk. So therefore, intent is also eliminated. Because,
but isn't an intentional intoxication not of a defense?
Well, the question is her obligation to get him out of the suitcase, and I'm not clear. I'm not researching it either. because I want to be able to view this
I haven't
case
even seen the video
through the lens of a juror. Oh, I have. I mean, when you look at the snippet, it's pretty bad. But the question is if she didn't put him in there, and he's in there,
but who zipped it up?
and she believes, well, allegedly he did, and left a finger's length.
Well, then he should have been able to undo it.
Well, that apparently, again, the stupidity of it, somehow it wouldn't get open, like zippers on a coat get stuck. And he's like, baby, I can't get out. And he ended up asphyxiating himself, not because he couldn't breathe because of it being sealed, but because of the position. It was positional asphyxiate, I believe. Again, we're finding this out of trial, but I believe it was due to how he was and he couldn't breathe. So
I can elaborate on the ME.
Well, yes. So it was a very slow, agonizing, terrible death. But the point is disturbing as the video is, what legally is she required to do in that instance? And again, is it murder? And I'm sorry I said that on our live, but is it that?
Red rum.
Is it red rum?
Yeah.
Oh, there it is. Red rum. Red rum. Is it red rum? Is it red rum?
Yep.
So is it? Because if it's not, because again, that requires intent. And there has to be an intentional thing that she did. Now, her negligence in not letting him out, her failure to her duty of care, or whatever you want to say, is somebody, again, I don't know legally what that requirement is. Because it would be like this. If
she intentionally chose not to let him out.
Well, yeah, but if she didn't put him in, if she didn't put him in. So the question becomes then, what he gets in, and then the question is, like, for instance, let's just say I was walking down the street, somebody's in a suitcase, and I hear him yelling, and I walk past it and go to my car, get in, and I'm like, that's weird. I don't know what the hell's going on. I'm not getting him out. Like, what type of weirdness is this? Guy dies. Do they come charge me?
Or if you see a couple fighting, punching on, and you don't step in because you're afraid of getting hurt, I suppose it's a similar thing, isn't it?
Well, the question, though, is what's the legal obligation? And
yeah.
In some states, there is none. You don't have a legal obligation to intervene. So that's the question that'll be at hand in that case. So it's not as clean and simple as just watching that video.
If you think she's in fear, she has a right to retreat, I suppose, too, doesn't she?
Well, correct. And then if he gets in there and she has a past history and he's beating her up, and she's
going to come down to a legal battle.
Oh yes. So that's why I said it's going to be a really, really interesting one. So
awesome.
Yeah.
All right.
Well, with that said, guys, I think we're going to go ahead and end this thing.
Thanks, everyone. Thanks, Flashman.
And yes, and everybody, please head over to the 3rd DCA. Make your presence known.
Yes. It's
and please,
linked in chat.
Yep, it's linked in the chat, and please do what you can. Yep. So
and don't forget to hit that like and subscribe.
Oh yes, hit the like and subscribe button on your way out. All right.
That'd be awesome, guys. Wicked.
Yep. All right.
Cheers.
On that note, let justice prevail.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose. purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm. United and free. United and free. United and free.